all. We come from Andhra Pradesh. My name is Archbishop Dr. Joshua Daniel Chegudi alias Ashok Babu, the National President of the Christian Joint Action Committee CJAC. With me is Reverend Chintada Anand, the National Vice President of the Christian Joint Action Committee CJAC. Today's subject is the appellant in this matter. Today we have filed a review petition as a petitioner in person in the Honorable Court along with written submissions. Honorable Justice Prashant Kumar Mishra and Honorable Retired Justice DVSS Swamayazulu served as a colleague on the same bench in AP High Court of Andhra Pradesh over a year. Together they have delivered judgment in approximately 200 cases. We believe this judgment is a biased because a senior advocate, the retired judge, appeared before his former colleague. As proof of the retired judge admitted in a ANI national media interview that the court accepted all their submissions. As per the written submissions on 24 March 2020, 24/9/2025. This action is in violation of the rules and precedents of the Honorable Supreme Court. Instead, a future, the judgment from the 26 August 2025, hearing this discrepancy is illegal. A Honorable retired judge acting as a senior counsel is the mastermind behind is this strong network. Illegal like Vajrakara in both the Honorable High Court and Honorable Supreme Court. The Honorable Judge who delivered the verdict in writ petition number 7114 of 2025 dated April 2025 in the Honorable High Court is a close associate of this retired judge. There is a public evidence on social media providing their long-standing close relationship since their times in the Unified High Court. Date 26 August 2025 and date 24 March 2026 in the Honorable Court's record of proceedings, the names of Honorable Justice Prashant Kumar Mishra and Honorable Justice Manmohan are present. However, the same of Honorable Justice Anjaria is missing. Again, I asking to the Honorable dignities dated 26 August 2025 and 24 March 2026 in the Honorable Court's record of proceedings, the names of Honorable Justice Prashant Kumar Mishra and Honorable Justice Manmohan are present. However, the name of Honorable Justice Anjaria is missing. This is in violation of the Honorable Court's rules and established judgments. Regarding the SLP criminal number 9231 of 2025, the Honorable Court had initially announced in open court on 26 August 2025 that the case was dismissed and the judgment was reserved. In solemn memory of the Christian martyrdom of Dr. Pagadala Praveen Kumar on his death anniversary, March 24, 2026. Suddenly, on 24 March 2026, a judgment was delivered in criminal appeal number 1580 of 2026, stating leave grant and dismiss. We are deeply shocked that the same case was dismissed twice. How can possible? Same case was dismissed twice, which is contrary to the rules of the Honorable Court. This judgment is unconstitutional against the principles of natural justice and violates the court's own precedents under Article 13. This judgment is void. The petitioner appellant herein seek a review of the judgment date 24th March 2026, as there is a manifest error of record and a serious discrepancy regarding the constitution of the bench and the history of the proceedings. 8. The Honorable Court did not provide our advocate an opportunity to present full arguments in the SLP, which is unconstitutional. Delivering this judgment after a delay of 6 months and 29 days, violation the established rules and judgment of the Honorable Court. If leave was granted on 26 August 2025, why was it not converted to a criminal appeal number for nearly 7 months? This is illegal. The respondents filed written submission on 24 September 2025. 29 days after the SLP was dismissed on 26 August 2025, which is against court rules. How can possible? After dismiss the SLP, they are filing written submission. This is truly violated Honorable Court rules. When respondents file submissions, a copy must be given to the appellant to allow for a reply. This was not done. When an SLP is converted into a criminal appeal, notice must be issued to the respondents. This legal process was ignored. When an SLP is converted into a criminal appeal, notices must be issued to the respondents. This legal process was ignored. After converting to a criminal appeal, the court must hear arguments from both sides, which did not happen here. The bench that dismissed the SLP on 26 August 2025 constituted of Honorable Court, Honorable Justice Prashant Kumar Mishra and Honorable Justice Manmohan. However, the bench that delivered the verdict on 24 March 2026 constituted of Honorable Justice Prashant Kumar Mishra and Honorable Justice Anjaria. Including the name of a judge in the judgment who was not present on the bench during the pronouncement is unconstitutional. Omitting the name of a judge from the judgment copy who was actually present on the bench is violation of natural justice. Delivering a judgment on 24 March 2026 for a case not listed in the today's cause list is a violation of rules and the Constitution. The judgment copy makes no mention of the proceedings of arguments held on 26 August 2025, which is a constitutional court rules apex court judgments principle natural justice violations. The official record of proceedings for 24 March 2026 does not include the name of one of the honorable judges who reportedly give the verdict to Honorable Apex Court legal principle natural justice. When the Honorable Court and Honorable Court confirmed injuries to the appellant, how can the case be dismissed? Once again, wounds was fine. How can dismiss this case? We are not asking powers of Honorable Court, Honorable judges. We are only asking so many violations in the Honorable Court Honorable Court judgment. When the Honorable Court and Honorable Court confirmed injuries to the appellant, how can the case be dismissed? As per Article 13, the 1950 presidential order is void and unconstitutional. According to the 1950 order, the Honorable Apex Court stated that evidence of conversion must exist in government records for assess. Article 123 subsection 2 and Article 123 subsection 3 state that any ordinance or order issued by the President is temporary. The Constitution of India states that if any order or ordinance is not approved within 6 months of its issuance, it shall automatically lapse. This crucial point was also not thoroughly examined. Then the Honorable President of India, Ramnath Kovind, issued the Constitution application to Jammu and Kashmir, Order 2019, CO Constitutional Order 273. Through this order, the old Presidential Order of 1994 and 1950 was suppressed, and it was declared that all provisions of the Indian Constitution would apply to Jammu and Kashmir. Subsequently, this resolution was approved by the Rajya Sabha on August 5th, 2019 and by the Lok Sabha on August 6th, 2019. For example, when Article 370 was revoked in 2019, the presidential order was immediately approved by both houses of parliament. This confirms that parliamentary approval is mandatory for any presidential order or ordinance. However, the presidential order of 1950 never received legal validation from the Lok Sabha or Rajya Sabha. If the 1950 order were valid, it must not violate the fundamental rights guaranteed under Article 14, 15, 21 and 25 to 28. Since the 1950 order violates fundamental rights, it is void under Article 13 and was defunct from the day it was issued. From 1984 to 2026, the judicial consensus has consistently maintained that while a person can change their religion, their caste remains unchanged because caste is determined by birth. The following judgments reinforce this principle. List of precedents and judgment: Kailash Sonakar versus Maya Devi in 1984. The court held that when a person converts to another religion, their caste of birth is not fully extinguished. Rather, it remains in a dormant state. Upon reconversion to the original faith, that original caste identity is revived. Indira Sahni versus Union of India, Mandal Commission case, main case number with petition civil number 930 of 1990. The Honorable Supreme Court observed that even after conversion to other religions, the social and economic backwardness associated with one's caste often persists. Pulliya versus State of Andhra Pradesh in 1996. This judgment further strengthened the view regarding the permanence of caste identity and its relationship with constitutional benefits. Gone Jairaj versus Government of Andhra Pradesh in 2008. A significant case concerned the verification of social status and the impact of religious identity of caste-based claims. Rajkumari versus State of UP and others. Allahabad High Court case number writ petition civil number writ petition criminal 51871 of 2008. Date of judgment February 13, 2009. This judgment was says Honorable Justice Ashok Bhushan Key ruling. The Allahabad High Court categorically stated that caste is determined by birth and it cannot be changed by any other means. This ruling solidified the solid feed the doctrine that a change in religion does not result in a change of caste. KP Manu versus Chairman Scrutiny Committee in 2015. For SCC 1, the Honorable Supreme Court reframed that person A that for a person to claim scheduled caste SC status after conversion, the original caste identity by birth must be proven to have survived. Muhammad Sadiq versus Darbara Singh Guru in 2015, Civil Appeal number 4870 of 2015. A landmark judgment affirming that a person's faith religion is a matter of choice, but their caste is an inherited status from the birth that remains legally recognized. The Honorable Supreme Court has ruled multiple times that higher courts should not interfere while witnesses are being examined in trial courts. The appellant's SC caste certificate have never been cancelled by revenue authorities and remains valid. The Bapatla District Joint Collector has hurriedly issued a notice directing the petitioner to appear for caste certificate verification on April 16, 2026. This notice was issued because the petitioner complained to the Honorable Chief Justice of India and Honorable President of India stating that the caste certificate was never cancelled, ruling that the SC/ST Act does not apply while the caste certificate is valid is unconstitutional. Usurping the powers of trial courts and revenue authorities is a violation of Constitution and natural justice. We believe that courts under the influence of the retired judge acted to protect the accused rather than uphold justice. We strongly assert that this judgment is invalid due to violations of the Constitution, court rules and inherent discrimination. We are holding this press conference at the very same venue where the Honorable Retired Judge and Senior Counsel previously held there. We have now exposed their behind the scene activities with concrete evidence. We have many more points to present and will bring them before the Honorable Court in the coming days. There is a threat to our lives and the lives of our families. According to a reliable information, those mentioned in the review petition are attempting to influence the authorities where their supportive governments are in power to file false cases against us and harass us. They are also making every possible effort to avoid the legal process. Furthermore, we wish to state before the honorable media that there is a grave threat to our lives, to myself, my family and those standing by us in this legal battle from the individuals mentioned in the review petition. The retired honorable judge, the senior counsel, their associated and their organizations, if any physical attacks occur or if anything happen to us or our families, these individuals shall be held primarily responsible. Thank you everyone for your time. We hope justice will prevail. 1 minute. I share some more things. See this. (1950) order versus SC/ST Act 1989. Let me see what about this difference between these two. On January 30, 1919, the reservation process for scheduled caste SCs under paragraph 3 of the Presidential Order 1950 is distinct. The Scheduled Caste and the Scheduled Tribe Prevention of Atrocities Act 1989, dated January 30, 1990, is an entirely different legal entity. Therefore, the SC/ST Act does not fall under the category of reservation. Reservation pertains to government benefits, employment opportunities, and other such provisions. Conversely, the SC/ST Act deals with personal attacks, harassment, and caste-based slurs directed at SC/ST individuals. This is fundamentally rooted in Article 17, abolish of untouchability of the Constitution. The SC/ST Act, the Presidential Order of 1950 are separate. Since the SC/ST Act did not exist when the 1950 order was issued, I submit that the condition of the 1950 order do not apply to the SC/ST Act. Article 17 versus Article 15-16. We argue correctly between protective legislation, punishment, discrimination under Article 17 and compensatory discrimination, reservations in jobs, education under Article 15 and 16. Context of paragraph 3. We are likely referring to the religious satire in paragraph 3 of the 1950 order. Legal scholars often argue that while the 1950 order limits reservations, benefits to specific religions, the protection from atrocities should theoretically be based on the victim's social vulnerability and historical background, regardless of the 1950 order restrictions. This act has full approval of the Indian Parliament. It is not merely an executive order. It is a statute act enacted by the Parliament. Details of parliamentary approval and legislation. Name of the act: Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act 1989. Parliamentary approval. It was passed by the Indian Parliament in the year 1989. Act number 33 of 1989. Presidential assist. The then President of India gave his assent to this act on September 11, 1989. Date of commencement. This act come into force across the country on January 30, 1990. So, today we are filing review petition. All we are totally different way. In that judgment, violations of principal natural justice, constitutional rights, honorable court rules, alage honorable court judgments. So, please pray. Thank you. Pastor ఇప్పుడు మీకు నేను తెలుగులో ఎక్స్ప్లెయిన్ చేస్తాను. ఇది ఈరోజు మన కోర్టులో ఫైల్ చేసిన కేసు. ఖచ్చితంగా ఈ తీర్పును మేము గౌరవ సుప్రీంకోర్టు వారిని, గౌరవ న్యాయమూర్తులను అపారంగా గౌరవిస్తాం. వారంటే మాకు చాలా ప్రేమ, మమత, అనురాగం ఉంటుంది. వారికి విధేయత చూపిస్తాం. కానీ తీర్పులో ఉన్న విషయాల్ని మేము పూర్తిగా పరిశీలన చేసినప్పుడు అవి రాజ్యాంగాన్ని, అలాగే గౌరవ కోర్టు వారి తీర్పులను, గౌరవ కోర్టు వారి రూల్స్ను, సహజ న్యాయ సూత్రాలను అతిక్రమించి ఉంది. కాబట్టి ప్రస్తుతం అయితే రివ్యూ పిటిషన్ని మనం ఏప్రిల్ 23లోపు వేయాలి. అందుకని ఈరోజే మనం ఒక 2 రోజుల ముందే గౌరవ సుప్రీంకోర్టులో రివ్యూ పిటిషన్ ఫైల్ చేసాం. దాదాపు అనేకమైన ఇక టోటల్గా మనం అంతా దాన్ని కవర్ చేయడం జరిగింది. ఈ విషయాన్ని మీకు తెలియజేస్తున్నందుకు చాలా సంతోషిస్తున్నాను. మళ్ళా కలుద్దాం.